Good afternoon, everybody. Thank you for being here. I see familiar faces, many. And no, I don't mean only my coworkers. And I'm really glad that I see you guys in every effort that we do at the International Human Rights section of the Bar Association. Thank you also to Raquel and Kelly and everybody at this institution that puts up with us, and co-chair Michael Sargent, who is a cheerleader of this Almudena ideas. And I am actually also thanking the two panelists tonight whom I will introduce in a minute. And I would just like to tell you that we have two professionals who is amazing that we can have at the same time, in the same town, in the same time zone, I should say. And it was a coincidence and it was an opportunity. So she said it was suggested by the whole idea of talking about this subject that we're going to talk tonight, and I think it's a great opportunity. So for that, I thank you guys in advance. I'm going to introduce, the way we're going to do it, and hopefully is something that you enjoy, is instead of giving them time to talk, which they can definitely do very long and very well, we decided that we agreed to have few questions, and they have given me the questions, but not all of them, that I will ask them, and then we start the dialogue and hopefully open up right away or in a little bit, for you guys to present your questions as well. So now the introductions. I'm going to start with, although I should have taken the left seat, but with the person next to me on my right, immediate right, is Professor Beth van Schaack. Do I pronounce it right? That's her last name. She's a professor of Santa Clara University, but right now a visiting professor at Stanford Law. She also was appointed, I want to make sure that I list these important appointments, in 2012, appointed as a deputy to the U.S. Ambassador at Large for War Crimes in the U.S. State Department's Office of Global Criminal Justice. It's a title that really gives me a lot of trouble, and where she's now a senior advisor. Beth is, besides a friend and a colleague and a lawyer of many years, she was also the executive director at some point of the Center for Justice and Accountability, where I work and many of us work. She went after that to Morrison and Forrester, but I think of her tenure, I would like to, of her many, many achievements, the one that I'm most obliged to point out was that she was one of the lead counsels in the legal team that brought one of the most important, perhaps I'm a little biased, but most important ATS cases at the Center for Justice and Accountability, which is the case on behalf of 3 torture survivors from El Salvador, known as Arce versus Garcia and Vides Casanova, which I think is being a legendary piece of litigation in U.S. ATS. And she was in that team and secured a judgment that awarded $54 million to our clients. They received very little. Everybody thinks they are millionaires now. No, but it was an important decision on torture under U.S. statutes. And then a little bit farther, much closer these days, is Toby Cadman, barrister at law from London, obviously, where they call themselves at International Chambers 9 Bedford Row, chambers with high relevance and prestige for having done important work, international work. Among other things, where he's an international criminal law specialist, and he specializes particularly in war crimes, terrorism, extradition, and human rights law. He served as a senior legal counsel for the chief prosecutor of the Bosnian war crimes chambers, and currently, among other things, serves, and I think that's one of the reasons we want to hear, as defense counsel at the Bangladeshi War Crimes Tribunal. As you said, the Beth also work at the International Tribunal for the former Yugoslavia. They both have important experience in those tribunals. Of all the work that Toby does in the international arena, I would like to, highlight his current work with the Syrian National Movement and representing victims of the current conflict in Syria in an effort to gather evidence, to preserve evidence, and to advise and procure a long-term transitional justice strategy for when this crisis, if ever, can be concluded, advising the ICC Office of the Prosecutor, coordinating investigations, and in general strategies to investigate and prosecute, hopefully for that ICC of all of us, crimes against humanity. So these two wonderful professionals and colleagues and friends also have quite experience with this Bangladesh international tribunal. I think it will not be anybody's surprise, since the tone of the conversation today will be of a critical one in relation to that tribunal. So my hope is to ask him questions to break down a little bit the history of the trial, the problems with the tribunal, the problems with that tribunal, and then make a general analysis for all of us about how something like that can survive these days with so much learned and so much done. And here we are with the Bangladesh Tribunal. So with that, first question is for Beth. Mm-hmm. Would you tell us a little bit about the origins, considering the timing, considering the I think how evolved international criminal law and international human rights standards? What are the origins in the creation of the Bangladesh Tribunal?
Sure. First, it's great to be here. Thank you. Thank you for that lovely introduction. And although I am still a quote-unquote senior advisor to the State Department, I'm here in my personal capacity, and nothing I say is necessarily the position of the U.S. government, although I have a feeling we kind of agree on a lot of this. But nonetheless, there's my official caveat. So the tribunal itself is very much a creature of the partition. If you remember when British India broke apart, and Pakistan at that point was actually in two places separated by thousands of miles. There was West Pakistan, which is now Pakistan proper, and there was East Pakistan, which eventually became Bangladesh. And in the elections in 1970, a nationalist, pro-independence political party that was very much in favor of greater autonomy for East Pakistan, which eventually became Bangladesh, won a landslide victory and began to assert rights of autonomy and independence as against West Pakistan. Needless to say, the West Pakistani government was not pleased with this idea and launched what was called Operation Searchlight, which involved a massive scorched earth campaign in East Pakistan. Thousands of people killed. Obviously, we don't have scientific numbers for this, but the low end of numbers is sort of 300,000 killed. The high end of numbers that we see goes up to 2 million. The numbers we see in terms of women being raped is low end 200,000, high end 400,000. So one of the largest wartime rape episodes ever, rivaling the so-called rape of Nanjing. Certainly what we saw in Bosnia. I mean, very much a concerted effort and systematized wartime rape. Thousands of people were displaced. At one point, there were 50,000 refugees crossing into India a day. So upwards of 10 million had moved across the border. All of this to try and quelch this independence movement that was being really organized and fomented by a political party called the Awami League, which is still around today, and they play a really important role in this establishment of this tribunal. India ends up intervening on behalf of the Bengali population of East Pakistan in what has been cited as an act of humanitarian intervention. It's one of those sort of historical examples that gets tossed about when we think about the legality of humanitarian intervention. This is considered one of those, alongside Vietnam intervening with respect to the Khmer Rouge, Uganda, Tanzania, et cetera, with respect to Idi Amin. But this is another one of these that gets cited. Eventually, the Pakistanis are routed. There's an unconditional surrender. They pull out. There had been a declaration of independence that is now recognized. Bangladesh emerges as a separate independent country. And at that time, they draft two pieces of legislation that are important. One is a collaborators law, which would purport to prosecute those individuals within East Pakistan who collaborated with the West Pakistan invading force. And the second was the legal framework that is the Bangladesh International Crimes Statute. At the time, it reflected very much where international law was, which was somewhat in a primitive state. We still had the Nuremberg and Tokyo precedent available, and so some of the definitions in that statute are very similar to that era. The ICCPR, the International Covenant on Civil and Political Rights, had not yet been fully promulgated, although the Universal Declaration was available, so there's some procedural problems. But at the time, it was not necessarily a terrible statute, and I think the Bangladeshi people were very proud of that statute. The vision was that they would prosecute Pakistani defendants and then collaborators. In the end, there was a tripartite agreement between India, Pakistan, and Bangladesh that recognized Bangladesh as an independent nation. And in the interests of clemency and reconciliation, it was basically agreed that nobody would be prosecuted. And so the law risked becoming a sort of a dead letter. So fast forward to the elections in 2009, the Awami League very much ran on a platform of, we have this historical injustice, it cries out for remedy, we've got this law on the books, I'll prosecute the war criminals who are still amongst us, who are still in our midst. And it was basically a campaign pledge. And so when there was somewhat of a landslide victory as against two opposition parties, Jamaat-e-Islami and the Nationalist Party, Sheikh Hasina was true to her word and launched this tribunal process. The law has been amended a couple of times, and we can talk about the specifics if people are interested in that, if there are questions. But the idea was to create a tribunal to prosecute surviving perpetrators from that era. In the end, and as Toby can describe in more detail, it's really senior members of the two opposition parties who are the only defendants who are being considered at the moment. And so it's a starkly political exercise of quote-unquote justice that's very one-sided. And there are a whole host of procedural problems with the way those tribunals are going. But that's the legacy, and that's the history of it. It was passed in the immediate aftermath of a horrific set of events that deserve a proper justice mechanism and that have been sort of dusted off and now applied to a current political context where it's being very much used as a way to marginalize the opposition parties.
Thank you, Beth. And Toby, how did you get involved in, if you can talk as a consequence of the structure and composition of the court or the way it's operating?
Sure. Well, first of all, thank you for the opportunity to be here and talk about this. I was told last year, actually by a member of the San Francisco bar, that an international lawyer is only really an international lawyer once he's been arrested and thrown out of the country and reported to his bar association for misconduct. And I'm proud to say I'm an international lawyer as a result of these trials.
I guess I'm not yet. That's so sad.
I'm going to remove it from
all
the
these
title.
years I assumed I was.
How I got involved, I'd just finished 8 years in Bosnia, and I'd just returned to the UK, and I was effectively Google searched by my clients, and they were looking for a British lawyer who specialised in war crimes. And I was fortunate, or unfortunate, that my name came up first. And so initially what I was asked to do was to just review the sort of fair trial aspects of this process, and without any real intention to get involved in defending these cases, but just to advise a political party that felt that they were being targeted by this process as to whether these trials were likely to meet international standards. And that really resulted in, first of all, speaking in the House of Lords in the UK in July 2010. And this is about 3 or 4 months after this process had really got started. And then one of my colleagues in Chambers, in our firm in London, agreed that we would go to Bangladesh and speak publicly and meet the judges, have a look at the tribunal, and really advise this group on what they could do to challenge these cases. And it was a very difficult process. We could see from the very outset that it was highly politicized. And so in October 2010, I travelled to Bangladesh. I was literally there for 24 hours, met the judges and met one of the prosecutors. And it was very much like rabbit in the headlights. They really had no idea what they were letting themselves in for. And we tried to help them as much as we could, using certainly my experience of prosecuting and setting up a national tribunal in Bosnia to try and show them where we thought the problems were going to come from. And we gave them some ideas of sort of questions that they could ask their justice minister for support. And the immediate response from the chairman of the tribunal was, well, can you ask him for us? Because we can't ask, because that's admitting failure. And they just were not prepared to do that. And so over the next couple of months, I got more involved, started to look at the legal framework more, started to understand a lot more about the conflict. And as Beth has rightly said, this is one of the worst conflicts in history. And as Beth said, the numbers are anything from 300,000 to 3 million, and nobody really knows. But the position that we've always taken is whether it's 300,000 or 3 million, it's deserving of a judicial response. And it's regrettable that it's coming, or it came, more than 40 years late. So I was then, through being involved in this process, officially retained by this political party, whose entire leadership was then being put on trial. And it's important to note, and as Beth has rightly said, that the defendants come from two political parties who are the main opposition parties. So the Bangladesh Nationalist Party is the main opposition party, and Jamaat-e-Islami, who are my clients, the Islamist political party, who were in a coalition government with the BNP before the Awami League came back in 2009. And lots of people have suggested that by targeting Jamaat-e-Islami, they are able to weaken the main opposition party, and that's really the intention. When you look at who can be prosecuted and who have been prosecuted, it really shows how politically motivated this whole process is. So, for example, there is, even before we get into the statute itself, there is a presidential decree that prevents the prosecution of anyone who fought for liberation. So anyone who fought on the side of the winners cannot be prosecuted. And that was really the startling realization that I made when we started to look at this entire framework, is that whether you consider my clients to be guilty or not, the fact of the matter is that no one on the other side can ever be prosecuted. And that's the starting point. The next point that you look at, if you look at the Constitution, and the Constitution of Bangladesh is actually very forward-thinking when you look at when it was adopted in terms of human rights protection. And there are numerous provisions in the Constitution that provides for fundamental rights of due process. But there is a constitutional amendment, the 1st and 15th constitutional amendment, that actually clearly states that none of these rights apply to anyone charged under this statute. So anyone charged with war crimes under this statute loses all of his due process and fundamental freedoms. So that's really the next startling realization. And then you start to look at the Act itself, and as Beth said, it is a creature of the Nuremberg principles. And in 1973, it was an adequate piece of legislation. But it's important to remember or to note why that legislation was adopted. It was not adopted for a civil court process. It was a military trial. So there were 195 Pakistani prisoners of war who were in the custody of India, who were handed over to Bangladesh to be put on trial. And this legislation was to put these individuals on trial. There was a separate legislation, as Beth has said, to put on trial collaborators for lesser offences, but for those offences that constituted war crimes, crimes against humanity and genocide, they were to be prosecuted under this legislation. So the 195 Pakistani prisoners of war, and they were put on trial, and they were convicted, but they were repatriated back to Pakistan, as Beth had said, in the interest of peace, stability, and long-term reconciliation. And Pakistan had agreed to put these individuals on trial before a Pakistani court, but they did not. And nothing happened for the next 40 or so years. But there are other aspects of this legislation that, even if you look at it in 1971 in the context of a post-conflict situation, of a military tribunal, there are aspects of it that are still deeply worrying. For example, there is reference to independence of the tribunal and the tribunal judges, but there's no reference, there's no mention of the word impartiality. And independence was inserted later on, but impartiality was somehow forgotten. The defence cannot challenge the appointment of any judge. for whatever reason. So that the tribunal chairman could walk into the courtroom, shoot my client dead, and I wouldn't be able to have him removed because there is no provision for it. And we have tried to have judges removed for actual bias, which I can get into later. So not only can I not challenge the appointment of any judge, I cannot challenge the constitution or the jurisdiction of the tribunal, and I can't actually challenge any decision the judges make. I can appeal against conviction and sentence, but I cannot bring any interlocutory appeal against any decision, and that includes a decision on bail. So if my client is held in custody, as they all are, I cannot challenge that decision. And following the State Department's involvement and Beth's office involvement, there was an amendment put in to satisfy the international community that due process would be applied, and that was that a decision could be reviewed by the same judges who make the decision. Now, we have submitted, at the last count, 237 motions, and I can tell you we have been unsuccessful 237 times. So, whilst we will hear that the involvement of the Office of Global Criminal Justice now had requested certain amendments to be made, and some amendments were made, none of them are, I would say, are practical, and none of them have made any difference in practice. So there have been cosmetic changes made to the process, but they have had no real effect. And in terms of the recommendations that Ambassador Stephen Rapp made, it's important to note that the government of Bangladesh told Ambassador Rapp that they couldn't change the constitution and they couldn't change the act, the statute, but they could make changes to the rules of procedure, and so that's what they did. But that was a lie, because they have subsequently amended the constitution on 2 separate occasions, and they have amended the act on at least 4 occasions. What they actually meant was they can't amend the constitution and the statute unless it's to the detriment of the accused. So that's probably a quick introduction.
Just to whet your appetite.
in terms, just very quickly, in terms of what I was actually engaged to do. Now, the statute and the rules provide for foreign counsel to appear for the prosecution or the defence. So the intention was that a team from my chambers in London would actually be conducting these trials. I was very critical of this process. I sent appeals to the UN and appeared on Al Jazeera and various other news outlets complaining that my clients could not possibly receive a fair trial in this environment. And I visited Bangladesh on 5 separate occasions. On the 6th occasion, which incidentally was to meet with an envoy sent by the State Department in August, on the 5th of August 2011, I was stopped at the airport, confronted with a dossier that had my name on the front of it, which was that thick, that had every reference that I'd ever made to the tribunal and to the government of Bangladesh. I was detained for 10 hours at the airport and then unceremoniously thrown out and told, do not ever come back. So what I've had to do effectively is to pioneer Skype representation. And that's how we've assisted our lawyers. There are very admirable attempts by Bangladeshi counsel to represent these individuals, bearing in mind that if you represent these individuals, you are a traitor to the nation, and these are statements by members of the government. And anyone who comes forward as a defence witness is referred to as a traitor to the nation. Any form of criticism is part of an international conspiracy against the government and is anti-liberation. And they have now passed a piece of legislation that makes it a criminal offence to criticise law enforcement or the military. And any criticism of the tribunal for a case which is under consideration is contempt. And a number of people have been charged with contempt. The Economist, Human Rights Watch, and a British journalist who's probably the only independent voice in Bangladesh have all been charged with contempt for daring to criticize this process. So that's my start.
Thank you. I guess, we can be talking about the irregularities of the tribunal throughout in a more horizontal way. And then I'll ask these couple of questions that I really, really want to ask you guys, and then I'll leave it for everybody else. But, I guess I'll ask you guys now to go into the speculation terrain as international experts and what I think is my concern, knowing very little, which is why my mouth is a little open about this tribunal and its implications. We've been struggling for so long to develop international criminal rights. Every single court and effort, from the ICTY to place a beginning in this Nuremberg principles vocation, to the ICC to talk about some sort of a culmination. I'm not saying the end, but a culmination. How does an experience like this can potentially affect, not only in the present time, but what kind of damage, if you guys will dare to speculate for us, can do? All of these efforts are so vulnerable, even though when they have proper statute, non-political bias of such kind, and international support, there's still being irregularities, corruption, ambivalent results. I have a colleague that works in Cambodia with a lot of struggle. And how do you guys, what can be the short-term, mid-term, and long-term consequences?
Well, I don't think there's any question that there's a consensus around the idea that when horrific acts happen, we need to have some sort of an accounting through a range of transitional justice mechanisms, including truth commissions, trials potentially, lustrations where you bar certain individuals from holding positions of power or with state positions in the state, et cetera. And the question is what each individual state decides to do with this panoply, this sort of menu of transitional justice mechanisms. So the idea that there should be an accounting for what happened during Operation Searchlight is without question, right? Now we get down to what are the details of it. So we have a trend, if you see in international criminal justice, of Nuremberg and Tokyo being the classic international tribunal set up by the international community working collectively, no real involvement by the domestic kind of quote-unquote target state. And then we had the ICTY and the ICTR for Yugoslavia and Rwanda, a similar type of a model, ad hoc, focused on a single conflict with the idea that eventually it would close down. The next model, step along the way, was more of a hybrid model where the idea was to embed some international component in the domestic legal system. So you had more of a empowering of that domestic legal system. And we have a whole continuum of these hybrid institutions, one of the best and strongest being the one that Toby worked at in Bosnia-Herzegovina, where there are specialized chambers with expert international counsel working alongside their local counterparts so that there's a technology exchange, there's a learning process that happens, and eventually a sort of sunsetting that goes on where the internationals withdraw and the body is able to move forward on its own, having worked under international standards for human rights and due process for the defendant, plus international definitions of crimes that are well-established definitions. So on that trajectory, the Bangladesh tribunal is a purely domestic entity. There's no international involvement, and in fact, early on, there were proposals made and offers made by other states, donor countries, to offer expertise, because there are people like Toby and others who have worked in these tribunals and who would have been available to be seconded to these efforts. And there was basically a sense of, no, we don't want this and we don't need this. We can do it. We drafted this statute on our own at the time. It's a terrific statute. Look how forward-leaning we were, right? We were one of the first nations to do this, and we don't want any interference, essentially, in our domestic process. So the result is a vitally, at the sort of genetic level, as Toby described, unfair process. And in a way, it does a disservice to the victims who deserve to have a fair process, putting aside even the rights of the defendants. Will this have any legitimacy in the eyes of anyone outside of Bangladesh? And the answer is probably no at this point. No one is supporting this tribunal. Even in the beginning, when it was first being contemplated, if you look at sort of press releases from Human Rights Watch, there's a tentative sense of this is worthy. let's get it right, here's some things that need to be done, and all of those efforts to reach out and provide technical expertise were essentially rebuffed. And instead what we have is a process that's degrading as we go along, and there's current amendments to the statute that are being considered that would revive the idea of even collective responsibility, which was a Nuremberg innovation that didn't go anywhere. It was sort of extinct after the Nuremberg era, and the idea being that you would prosecute and convict organizations, and then anyone who was a member of that organization would be sort of presumed to be guilty unless they could come forward and rebut the presumption of guilt. And that was the vision of what you would do with the SS and the Gestapo after World War II. The tribunal sort of went along at Nuremberg, although didn't convict all of the organizations that had been indicted. And then in subsequent prosecutions, everyone was so uncomfortable with this idea of sort of guilt by association that essentially there was no res judicata effect, that each individual that was prosecuted as a member was essentially given an opportunity to fully defend themselves, and the burden rested and remained on the prosecutor. Well, now this legislation, they're considering even amendments that would make organizations like Jamaat, which existed back in 1970 and now exists today, potentially a criminal organization. Is there continuity between those two political bodies? Not necessarily, right? This is a completely different political realm. Nonetheless, again, you can see how it can be used as a tool to consolidate political power. So we're creating a system that's ostensibly for the victims, and yet it's so unfair and lacking in credibility and legitimacy that will it satisfy the victims? Now, frankly, what you do see is a fair amount of bloodlust in the populace, where an individual gets a life sentence and riots erupt in the street calling for the death penalty. So to be fair, it's not just the government manipulating the situation. There's a fair amount of grassroots political energy around these tribunals. I don't know to what extent that's being fomented by the government and to what extent that's a sort of authentic or indigenous reaction. And Toby, you may have a better sense of that from the populace. But there is a consistency with the government's position and with what the populace wants to see in terms of outcomes from these trials.
No, I think that's right. And it's fair to say that a number of organizations, not just Human Rights Watch, had really commended the efforts of the Bangladesh government to initiate this process or to reopen this process. But that died very, very quickly. One example, the International Center for Transitional Justice had provided some support by taking the judges to The Hague so they could observe proceedings at the ICC, at the Lebanon Tribunal. And for all the criticisms, it was important for the judges to see the Lebanon Tribunal because Bangladesh also has trials in absentia. So it was important for them to see how that process would work. And we, of course, supported all of the efforts by ICTJ because that was aimed at improving the process. Unfortunately, because of a number of things happening, ICTJ decided to withdraw support because they didn't want to be tainted with legitimizing a failed process. And so all support was withdrawn. And there is nobody that I'm aware of has ever came out and tried to defend this process. All of the comments have been just criticism. And leading on from what Beth said in terms of this lust for blood, I think that it is important to recognize how the Awami League, the current government, came to power in 2009 on this election pledge. So there was clearly a desire for a system of accountability to be initiated. But what we have seen, and one example that Beth gave, and I'll just explain that in a bit more detail. So the first person to be convicted, one of my clients, and the first person to be executed, we shouldn't forget that one person has been executed so far. He was initially convicted and sentenced to life imprisonment. And he came out and showed the victory sign to his supporters. And that was interpreted as, I've won. and we'll never know what he actually meant by that. But it caused a mass demonstration. Approximately 100,000 people took to the streets calling for him to be executed. Now, the difficulty that the government was faced with at that time was that the law as it currently stood did not allow the prosecution to appeal against sentence. And so, as a result of these demonstrations, the Prime Minister went into Parliament and did two things. She called for the law to be amended so the prosecution could appeal, and she made the statement, and her words were, "I will go to speak to the judges, and I will make sure they understand the sentiment of the people." And she did, because in the very next verdict that we saw, the line can be taken out, the sentiment of the people. And so that had a direct impact. But the law was quickly amended, the prosecution appealed, and the Supreme Court upheld their appeal and passed a sentence of death. Now, there was a lot of criticism of this, including from John Kerry, who telephoned the Prime Minister herself and called for her not to carry out this execution, because there was no right of appeal from this sentence. And this was not, the death sentence was a sentence at first instance, so we had no right of appealing that. Again, we had the right to review that decision by the same judges, which of course I think they took 15 minutes to deliberate, and he was promptly executed. So you can see the interference, the attempts by the international community to try and have a dialogue with the government to ensure that this is a proper process, and it's just repeatedly failed.
And the last question from me, promise guys, hopefully you have many. I have to take advantage in the best sense of the word of having Beth and ask her, to the extent that you can, to talk about the U.S. approach and what is the U.S. the current position of what is in the works to be done.
Mm-hmm. Well, my former boss, Ambassador Rapp, who's the ambassador at large for war crimes issues, has been to Bangladesh several times. And he, as Toby mentioned, he wrote at one point a very long letter which set out a series of suggestions of what could be done to modernize the 1973 law, bring it up to international standards in terms of human rights and the rights of the defendant, and also in terms of the substantive law that was available, so that the substantive formulations of the crimes very much borrow from the Nuremberg era. And there's been a lot of jurisprudence since then through all the war crimes tribunals that have updated those definitions. And so there were ways that you could have updated them that would have been more clear in terms of what the elements that needed to be proven, et cetera. So this letter was meant to be a private letter to the individuals who are involved in creating the system in Bangladesh, and it got leaked by someone on that side, and so it was made public. In the end, there were some changes, as Toby mentioned, to the rules of procedure, and there were some improvements made in terms of right to, protection against self-incrimination and this and that. There were some things that were embedded in the rules of procedure and evidence that improved things for defendants, but many of the recommendations that he made were not taken. And so the next line of sort of strategy was to keep these guys alive, essentially, right? So let the process happen, let the convictions happen as they will, but make the point that the death penalty needs to be reserved for only those cases that are scrupulously fair, where the evidence is overwhelming, et cetera. It's obviously in a very difficult position coming from the United States, which accepts the death penalty at the federal level and also sees it at the state level, that it's actually being used at the state level, to take a hard stand against the death penalty. And so this is the line that gets walked, is that it's got to be fair and that the evidence is overwhelming and this and that. And when you have individuals being convicted on the basis of testimony that's contested and uncorroborated, it doesn't satisfy that sort of demand for almost an even more heightened standard when the death penalty is on the table as an option. And so there was, as Toby mentioned, a big sort of full court press when it was clear that the Supreme Court was going to, or had, increased the penalty and removed any opportunity to appeal. If you remember, the ICCPR makes very clear in one of the enumerated due process rights is you should have a right to appeal. And when it's the Supreme Court, as the appellate court, that's instituting an increase of a sentence from a life imprisonment to the death penalty, that's obviously even more worrisome in terms of denying defendants the right to appeal. To be fair, just as a little side note, some of the war crimes tribunals have seen this practice where the appellate chamber of the ICTY or the ICTR has in effect recharacterized or potentially even increased the sentence of criminal defendants. And so there's unfortunately some precedent that can be pointed to. And if you read some of the judgments that come out of the BICT, the Bangladesh International Crimes Tribunal, you see them, they are citing international jurisprudence. They are reading those cases. They've got lawyers that are obviously working hard at reading these cases, but it's a very selective sort of a citation mechanism where things are taken out of context. But nonetheless, this practice is out there, and it's generated this sort of consistent dissent at the ICTY and the ICTR, particularly from Judge Pokar, who's the Italian, who's sort of outraged at the tribunals doing this. But here we have it a fortiori in even a more serious sort of a situation. So that has been the effort, because there was some sort of a sense that this was a little bit of political theater, and she made a campaign promise, and so we had to play it out. The individuals would all be convicted. Some have been acquitted on certain charges, so it gives this sort of a little bit of a picture that there's some deliberation potentially happening. Who knows? Life sentences or a sentence for a term of years would be issued, and then quietly perhaps there would be acts of pardon and clemency and this and that. And so that was one potential model, right? One trajectory that we could have been on. And then in a matter of 48 hours, an individual is put to death on the basis of this really problematic procedure in the Supreme Court. And so now it's really real. I mean, this, and it could happen to all of the defendants that are potentially at risk. So that's why even it went as high as Secretary Kerry calling and saying this is a moment when an executive intervention in terms of pardon might be appropriate, or the prosecution not pursuing the right to appeal that had been recently given to it. But that advice was not taken. So.
Wow. Thank you guys very much. I'm gonna open, if that's okay, guys, for you, for the questions. I wanna say two things. One, this is a small and very, I think, intimate group, so I encourage you to ask openly questions to these beautiful professionals. I don't think we have them this often together. And two, I may repeat the question when you, not because I'm annoying, but because, although I am, or I may be, is because they're being asked to make it clear for the record, this is being, webcam is the proper, so I'm going to repeat your question if that's okay. And please, Michael.
I would like some clarification of my confusion. At first I heard that there were only two defendants and they were the leaders of the opposition, and that they were apparently repatriated to Pakistan, to West Pakistan. But then I hear later about an individual whose life sentence was commuted to capital punishment, and was there only one? I mean, are these different trials?
Yeah. You want to clarify that?
Yeah.
Just really quick, I'm going to say Michael Sorgen is asking about clarifying the defendants, those charged, and for what? Anyway, whether this is one trial or several. And just
in the 1970 proceedings versus
exactly the 2014 proceedings.
So the individuals who were repatriated back to Pakistan was in 1973, 1974. So they were put on trial. That process was then stopped. They were repatriated back to Pakistan.
And those were the individuals for whom this legislation was originally drafted. That was the vision, it was almost a bill of attainder for these 195. No. Long gone at this point. Fast forward.
And these are the individuals who were identified as those bearing the greatest responsibility for the crimes committed in 1971. So fast forward to 2010, a number of individuals were arrested who are not two individuals, but members of the two political parties, so the Bangladesh Nationalist Party and Jamaat-e-Islami, of which I believe there are 14 defendants. And it's right that some of them have been acquitted of charges, but none of them have been acquitted. There are also 3 in absentia convictions, and one of them of a US citizen.
Oh, wow.
So a individual originally from Bangladesh, from New York, was convicted in his absence and sentenced to death. There has been no request for his extradition, and he, as far as I'm aware, still resides in New York.
Naomi, gentleman with the glasses, and then I'll go around. Naomi.
Just a follow-up question to Michael's. So those who bear the greatest responsibility are sitting pretty in Pakistan. So any effort to extradite, mutual legal assistance, nothing?
Nothing.
So the question is, what about these 195? And actually, there were hundreds of potential war criminals. The lower-level individuals, they were being held in the 3 countries. Each had non-citizens in their custody at the end of the war period. And as part of this tripartite agreement, sort of normalization of relationships, there was a massive effort at repatriation. So those individuals all shifted around. No, there's no effort. And I mean, I think Pakistan is watching this process. Their reputation is on the line. To give Pakistan, now Pakistan, then West Pakistan, some credit, there was a sort of a commission of inquiry that was established in the 70s to look at the conduct of the Pakistani government. And a report was drafted that was quite critical. It missed some things. I don't think the extent of rape was ever acknowledged. In fact, we were too disciplined for that, sort of was the line, and we would never do that, was the line that was taken. The report was never released publicly originally, and in fact, the story gets told, and you may know more about this than I do, but the 11 of 12 copies were destroyed because it was so critical. And there was this 12th copy that got leaked, or parts of it got leaked. And eventually, over time, with the sort of, benefit of distance, it was eventually declassified and now is available on the web, and there's some supplemental reports as well that you can find. But that is as far as it went, and Pakistan, I don't think, ever did no domestic proceedings. So it's a little bit like if anyone studied the East Timor Tribunal, you have this bizarre situation where a hybrid tribunal is set up for East Timor with special chambers, including international experts, and yet no jurisdiction over Indonesian defendants who were the primary movers and shakers of that violence. And so what you got was tribunal prosecuting kind of low-level cases of plunder, and, I mean, not to be diminished, but nonetheless it was not those who bear the, quote, greatest responsibility, which is often where we hope to see these sort of special tribunals focused on, is individuals who bear the greatest responsibility.
And just to add to that, the position that we have taken from the defense is that this is a process deserving of an international tribunal, because only an international tribunal would be able to put those in Pakistan and those in India who bear responsibility as the political and military leaders of the time. Of course, many of them are now dead, but not all of them. And so we've made this push for the UN and governments like the US, the UK, who have interest in Bangladesh, to push the agenda for establishing not a fully blown international tribunal, but a tribunal potentially outside of Bangladesh that has international judges and international prosecutors very much in the same way that we discussed about Bosnia. That way, the right defendants would be put on trial. My clients would have some satisfaction that they would actually have a fair chance, and that this process would have some credibility, and the victims would have some sense that justice is being served. Now, before this process started, there were calls for this to be a UN-sponsored process. Pakistan voted against that in the UN General Assembly because they have arguably the most to lose. If it's a credible process that establishes genocide, then Pakistan has the most to lose. Now the position is that the government of Bangladesh is preventing it from being a truly independent process because they won't be able to manipulate it. And the quality of the evidence is so shockingly poor that I'm quite satisfied that they would not even get past a confirmation of indictment stage, let alone a conviction. And they know that. If you look at the evidence that convicted and ultimately sentenced to death Abdul Qadir Mullah, who was executed in December, it was the statement of one witness who claimed to have observed my client raping and killing her entire family. The evidence that she gave at trial was truly compelling, and any jury would arguably have convicted on that basis. Until you look at the two previous statements that she had made, where she didn't even mention that my client was there, didn't even mention his name. She referred to the crimes being carried out by the Pakistani military, and in one particular statement acknowledged that she wasn't even there, that she'd been told this. So here you have a great opportunity for the defence to put two previous inconsistent statements to the witness. We were not allowed. We were told that it's not evidence. And so this was the evidence that ultimately sent Mr. Mullah to the gallows. So we know that the strength of the evidence is very, very poor, and there would have to be completely fresh investigations if this was an international process, and that's what the government is most worried about.
Right.
Yeah, thank you for this expose. And it seems to me any number of the things you've said would be reason to discredit this tribunal entirely. And I see in your report you're calling for some national strategies, which I read to be in lieu of lifting this tribunal at all. The strategy on transitional justice and national war crime strategy. And I'm wondering how you see those actually being implemented. I know you have some general objectives there at the end, but it seems to me that could suffer from the same problems as the internal process that this tribunal does, compounded, of course, by the passage of 40-plus years. And although there's no statute of limitations on the war crimes, so as to these individual processes that may go on, I just wonder how you can achieve any of the results of reconciliation or punishment, truth, given that passage of time and given the inherent problems you have just domestically and conveying that.
Well, I'll try and uncharacteristically give a short answer.
But restate the question first.
Oh, sorry. So how do we achieve or how do we implement some of these transitional justice processes that is set out in the report 40 years late, considering the way the trials have been conducted? First of all, what is set out in the report are recommendations to do in addition to a trial process. There still needs to be a system of justice and accountability. That's clear. The first thing that you notice when you arrive in Bangladesh is everything is about the Liberation War. Absolutely everything that you see is a memory of the Liberation War. And this is constantly used by the main political parties to fire against each other, to score political points. And there hasn't been any true process aimed at reconciling the two communities, those that favoured a unified Pakistan and those that fought for liberation. In order for Pakistan to move forward, they've got to address some of these issues, and it's not just a matter of holding a number of individuals accountable, that there has to be a proper process. There is a Liberation War Museum, which is supported to some extent by the international community, although it's become a political tool more recently as a result of these trials. But that is sort of the starting point for establishing some kind of a historical record. Because one of the big difficulties we have is there's no reliable data as to the number of victims, the number of rape victims, and if you dare to challenge the 3 million, as one British journalist tried to, he was charged with contempt as a result of challenging the fact that 3 million people died. So all of these issues need to be dealt with. Then there needs to be some form of rehabilitation of victims, and there needs to be a long-term strategy, and there is none. The strategy is to put on trial a number of political opponents, execute them, and then move on. That's it.
I was Lisa, and then you wanted to ask a question?
I just have a quick question, a background question about the judges.
Okay, well, we want to respect the, okay, go ahead, sorry.
So with regard to the participation potential or actual of victims or private civil parties, is there a mechanism for that in this tribunal, such as you would see in maybe other truly hybrid or international tribunals or in domestic proceedings like in Myanmar?
No, very, very surely there is no mechanism for civil parties, none at all. And again, going back to the previous point, these individuals are brought in front of the tribunal. They give their evidence, and then they're forgotten. And that is really one of the real dangers of this process, is that these individuals, whether the evidence they're giving is true or not, they are being paraded in front of this process, and then they're just being cast aside. And we have lost 2 witnesses so far.
Due to?
One, a prosecution witness was killed. Now, it may have been related to the trials. It may have just been an ordinary criminal incident. We don't know. The other witness, and this is one of the most startling examples of this process. So, one of the other defendants was convicted and sentenced to death on the basis of a written statement, amongst other things. So this particular witness, who is a Hindu who has no political affiliations whatsoever, his brother was killed by the Pakistani military during the war. He was a prosecution witness, and then he just disappeared. We found him, and the defense had said that he may have fled to India. We don't know where he is. So we found him, and he agreed to give a statement for the defense saying, I never said what's contained in my statement, and I'm quite happy to give a statement on behalf of the defense to say that the Pakistani military killed my brother, not this defendant. So we brought him to the tribunal. We had alerted them the day before that he would be giving evidence. He was abducted on the steps of the tribunal by plainclothed officers, bundled into the back of a car, and driven away, never to be seen again. We were alerted about 3 months later that he'd been found in Dum Dum prison in Calcutta, serving a sentence for being an illegal immigrant. And we were able to get a statement from his lawyer that says he was abducted by Bangladeshi police. He was taken to an infamous branch called DB1, which is where many torture interrogations are carried out. He was held there for 5 weeks, where he was tortured daily. He was then driven to the Indian border and thrown across. Now, hundreds of Bengalis are killed crossing the border, and so we assume that that was the intention. But he was arrested, and he was taken to jail, and he served a 3-month sentence, and he's still in India. The tribunal still convicted my client on the basis of his written statement and imposed the death sentence. So the witness issue is something that really needs to be addressed, and this is one of the main reasons why we have called for the trials to be moved out of Bangladesh, because the political environment is such that you cannot hold trials under these conditions.
Do you want to answer her question about the judges? Who are the judges?
A question about the judges.
Ties directly into that. Do the judges in the selection process, do they have any independence, and are they basically just the mouthpiece of whoever's in power and are perhaps afraid of their own lives?
I think there is, in terms of how the judges are selected, whether they are impartial, whether they are independent from the government, it is maybe best served by one particular example. So the president or the chairman of the tribunal, we were able to identify that he had an alliance with the ruling party, and we were able to identify that in the early 1990s there was a people's court that put on trial a number of individuals, including some of my clients. In this public showing, So they held these mock trials. They convicted all of the defendants, and they would hang. They would have sort of mock executions of these individuals to signify what had happened. We were able to identify that the chairman of the tribunal was a lawyer at this commission. And so we filed an application for him to recuse himself. And of course he didn't. We couldn't have him removed because, as I said, there's no basis in the law for us to do that. So we wrote to the judge privately recommending, in the interest of justice, that he steps down. That letter was leaked to the press, and that's when I was then reported to my Bar Association for misconduct. He was forced to resign later on when The Economist uncovered a number of Skype conversations that he had had with a Bangladeshi law professor in Belgium, where they were discussing how to prepare the prosecution witnesses, how to target the defense, including me, and discussing the judgments, drafting the judgments together way before the trials had even finished. So when this was uncovered and published in The Economist, and that's why they were charged with contempt, the judge was forced to resign. So the judge resigned, another judge was appointed, the trial continued, and my client was convicted.
In front of a judge who hadn't seen all the evidence.
So, and it's also important to note that there are a number of Bangladeshi professionals, including investigators, that worked at the ICTY and the ICTR. There is a judge in Rwanda who's a Bangladeshi judge. None of these individuals with experience of war crimes cases were selected, and they chose a number of individuals that have no experience of dealing with international cases and no understanding of war crimes. And to give what is my favorite example, in the reading of the indictment in one of the cases, one of the judges asked the prosecutor, "Can you tell me why you've charged this particular act as genocide and this particular act as a crime against humanity when they're the same?" And the prosecutor said, "If it's a single murder, it's a crime against humanity, and if it's more than one, it's genocide." That's the level of understanding.
Then we have Nico, and then I have 1, 2, 3.
I have several questions for each of you, and then a request for a comment. Question for Beth is, if there was a clemency agreement following the war period, didn't that result in an amnesty law, and how does the statute still have force if there was that intervening act? Second question for Toby, as this is such a politicized trial, tribunal, I believe Beth mentioned that the two opposition parties had been in a coalition government just 5 years ago, and that suggests that they have some support amongst the populace. And so I'm wondering, from just a sort of straight political read, how is it that it seems to have gone so far in the other direction with hundreds of thousands crying for blood and apparently a sizable percentage of the population not being heard that presumably wouldn't support this? And then a final question for both of you to comment. All of these international tribunals, dating back to Nuremberg, have always had the shadow hanging over them that this is victor's justice. And to what extent, I mean, obviously there have been great gains made to legitimize and develop procedures to demonstrate the fairness of this whole endeavor of international tribunals. To what extent does this example risk undermining all the progress that has been made and result in just dismissing all of these as victor's justice?
Yeah. So the first question on whether or not they should benefit from a pardon because there was this decision made when this normalization of relations happened. And it's a good one, and I haven't actually looked at the particulars. There's a presidential decree and this and that are extant. The defendants have raised this. I think one of the arguments is that to the extent that there was a presidential decree, it, I think as Toby mentioned, only covered so-called freedom fighters, individuals that were fighting for the liberation and independence of Bangladesh, and so it wouldn't necessarily have covered others. But I do think in the actual tripartite agreement itself, there is a sort of mutual agreement not to prosecute each other, but maybe it doesn't cover their own nationals. But I know defendants have raised this, and that claim has not withstood. I mean, the law takes precedence, and the ability of the prosecution to move forward has taken precedence, and so it hasn't provided necessarily an affirmative defense.
I think, just very quickly following on to that, the position taken by the government is that whatever amnesty was in place in 1974, it didn't cover murder, rape, and torture, and effectively didn't cover war crimes, crimes against humanity, and genocide. It would cover everything else, but not those. Now, we've taken a position that that's not right. When you read the text of the tripartite agreement, it covers all conduct, whether that's right or wrong.
Well, I remember reading somewhere one of the briefs of the government said something like, basically impugned the tripartite agreement and said we had no right to extinguish these charges for these particular offenses because they're, the most serious offenses under international law. And so actually impugning the very agreement that served as the premise for the independence of Bangladesh and the recognition of Pakistan. So,
in relation to your second question, that there is obviously a sizable opposition. The country is splitly drawn along these political lines. No democratically elected government in Bangladesh until now has secured a second term. So there is a major swing every election. And it's between the current Prime Minister, who's the daughter of the founding father, and Begum Zia, who is the wife of another important person during the Liberation War, and these two women have been battling it out for the best part of 4 decades. In terms of there being a sizable opposition, there have been mass demonstrations every time there has been a conviction, and there have been several hundred people killed on the streets in just the last 12 months. As a result of that, we have filed a request with the prosecutor at the International Criminal Court to initiate an investigation, because these are government security forces that are targeting civilian protesters, and several hundred have been killed. There was an election in January of this year in which the opposition was largely expected to win. They made the decision to boycott the election because they did not consider that it would be a fair election, a decision which has ultimately caused them a great deal of grief, because the Awami League was able to win the election without a vote even being cast. The hope was that the opposition would win and that they would make the decision to refer these cases under international jurisdiction. Unfortunately, they're going to have to wait another 5 years before they can do that. But there are very strong tensions, and we are expecting those tensions to become even stronger now that the leader of the opposition has announced fresh demonstrations. We are expecting more people to die on the streets. We are expecting 2 new verdicts to come out within the next few weeks, which will be 2 further death sentences, which will cause more demonstrations and more turmoil. And what we are seeing, and it's not exaggerating the situation, the country is being thrust very closely back into serious conflict. And that's what we've been warning the international community of from day one, saying if you allow this to happen, this is the result you're going to see. You're going to see extremism fostering in Bangladesh. We've already seen statements from Al-Qaeda, because a large number of the individuals who were killed are members of an Islamist group. And so that whole process is starting to play out as we feared.
I'm going to ask you to hold on to the third question, because it's a little bit, and I want to give everybody opportunity to ask. So how about I get all the questions, and then I give the word to the speakers, and that way they can address all of them. Is that okay?
Okay, my turn. I have a cluster of questions. And the first is just to clarify what you were saying, Toby, about the judge who was forced to resign. Was he forced to resign really by government, or did he resign because of the evidence that The Economist
the compelling evidence that was put forth. I was just curious about specifically whether it was voluntary, pseudo-voluntary on his part.
We're going to get all the questions first,
Sure.
and then you guys answer. And I'm going to make a list if you don't.
Okay, that's not, so that's just a clarification. Then another question, is there a discrete number of defendants that is known such that once they are dealt with, this process will sunset? And another question, the report and recommendations that you've made, to whom have you made those? And what's your expectation that anything positive will come from that? And the last question is there any modern day model of a transitional justice tribunal that works well? And if there is, what are the qualities that make it work? And is the
That comes loaded. That's a loaded question.
agreement of the subject country a prerequisite? Is the UN involvement a prerequisite?
Wonderful. We can talk that with Nick, because that's what I thought that question will generate a bigger. And yes.
For this question, we had talked a little bit about these different models: international tribunal, hybrid tribunal, and domestic, which is what we're looking at here. And I wanted to know if you had seen any movement domestically within countries talk about constitutional protections for due process. Has any international attention, just looking at the International Criminal Tribunal, helped strengthen domestic due process within Bangladesh courts? And also, kind of along with that, has there been any domestic outcry within Bangladesh around issues specifically of due process, not so much about the political issues that you were just speaking about?
Perfect. Maidali?
My question draws on some of the things that have been brought up, but I'm interested in getting Beth's take. With Ambassador Raab providing a letter to the Bangladeshi government with technical recommendations and constructive improvements, and ICTJ's decision to pull out of engagement, is there a concern that by pulling out of flawed processes and calling for their disbanding early on, that you're going to result in an even more flawed process? And what are things that maybe could have been done by ICTJ or other people to that are constructively engaged?
And if it's okay with everybody, that will be the last, well, Nushin. I don't want to leave you hanging. And then I want to allow them and not take you home before 9 p.m., but allow them to answer all of them fully. Yeah, Nushin, the last question, if it's okay.
My question is similar to Maidali's, that is there any international aid going to Bangladesh that also goes towards these courts, and is there any efforts to create a restricted aid in light of all of these allegations of problems of impartiality and independence of the court? I know that this is a common problem in Cambodia, and Ambassador Raab had spoken out against the problems of judicial independence, yet continue to provide funding and aid to the court system there. Is there any discussion of creating restricted money to these courts?
Thank you. The floor is all yours. You guys want to start with
The judge.
Yes, please. Yeah. I have it.
Okay. In terms of the judge resigning, I would say that he was pushed. Initially, when he was confronted with these allegations, he denied that these discussions ever took place. And then the recordings were all over YouTube, so it was a bit difficult for him to do that. So then he said, yes, but it's okay because judges can take the advice of lawyers. And then that wasn't going to work because of the nature of the advice that was given. So then he had to step down. There have been other judges who've been pushed. There was a judge who suddenly retired or resigned due to ill health. When we inquired what the ill health was, he'd hurt his knee, and he couldn't climb up the steps to the tribunal. So that's why he had to withdraw. So there have been a number that have been pushed. I think that they were very reluctant to let this particular judge go because he was known as the hanging judge. And he had been promised appointment to the appellate division of the Supreme Court if he convicted and sentenced to death 2 defendants before Victory Day. So there was a lot of reluctance in him stepping down, but it was clear that he had to step down.
Then about the number of defendants, can you address if there will be a number, at some point this will be a sunset or a finish to this?
Well, we believe that there are about a half a dozen more that they will want to put on trial. We don't know for certain. There are various different lists that have been circulated, but that also changes quite frequently. So, for example, one particular defendant, Mir Qasim Ali, who is he's one of the wealthiest members of the political party. He was arrested because there was an allegation that he was funding the defence's lobbying activities, and he was then arrested, and now he's been put on trial for war crimes as well. That was not somebody that we were expecting to be arrested. Our lead defense counsel, he is also a member of the party. He is at risk of arrest as well, and so he's currently in the United Kingdom, and he can't return because he will be arrested when he returns. Not just on these allegations, but on a number of other false allegations. So we believe that once they go through this particular group, that probably will be it, but they will want to drag it out for as long as possible for full political gain.
I would like to guys, both of you, address now what I think is a little, mix between Nico's last question and your last, which is, is there any model tribunal? Is it just a victor, the winners or whatever, the way Nico phrased it? Is this a failure all along for these efforts?
I really don't think it is. I think a number of them have been, we can call successful. I think the Special Court for Sierra Leone was a success. I think the special chambers in Bosnia have been a success. The Cambodia Tribunal obviously is a much more mixed bag in terms of just fairness and impartiality and, allegations of some corruption and political interference in decisions on particular prosecutions and the cost of the thing in terms of just the sheer number of defendants who are going to be faced there. Looking at things, at systems like Guatemala's, where there's some international assistance in the office of the prosecutor and the choosing of the cases, and so those cases are moving forward in a domestic system. Is that a really hybrid tribunal? Not really, but at least there's a dialogue that's happening at the vertical level where the national system is getting assistance from an international system. I think those are working. I don't think East Timor was a great success of international justice. Maybe it was better than nothing, which was sort of the alternative on the table, but certainly was not a great resounding success. I think the ICTY and the ICTR are great successes, even though they cost a fortune, in part because of the jurisprudence that they created. I mean, that is, in the words of, I don't know if it's American Express or MasterCard or whatever, but that's priceless, right? I mean, in terms of having an ability to draw on that jurisprudence now when it comes to what are the elements of crimes against humanity or how do we prove complicity at the international level. So it's hard to, each one has decisions that you look at and you think, that's a terrible decision, but how different of that is than the Ninth Circuit, where you occasionally look at decisions and think, oh my God, what were these guys thinking? So I don't think it's all a negative. I think we are learning from our mistakes. I think the hybrid model is going to be the model of the future, where you empower the domestic system but include international expertise, and I think you do need the consent of the quote-unquote target state to do that. It's very difficult to impose a tribunal on a state, and I think this is where this effort of an international one is absolutely the right one, but it's going to be very, very difficult when the defendants are in Bangladesh and the evidence and et cetera. We saw that when Rwanda was getting annoyed that the prosecutor Carla Del Ponte was looking at Rwandan Patriotic Front, i.e. Tutsi, potential defendants, and they basically shut down cooperation. No witnesses could travel, visas were not being issued, evidence was stuck in Kigali and couldn't get to the tribunal, which was next door in Tanzania. And so you can see the ability of the state to control the effort if they don't like the direction in which it's moving. So you really do need some level of consent, I think, from the target state.
Do you want to give your opinion?
No, I think... yeah, we're very good at doing it badly, and I think the next one's going to be really good. At least that's what we hope. Now, I think that you can take examples from different tribunals where some things have worked, some things haven't. I do like to think that the Bosnian model, primarily because I was involved with it, is one of the better models, and I think that is possible in Bangladesh, and it's not too late. I think if they go any further, it will be too late. But there is still time to correct this. It needs a new statute, it needs international supervision for a period of time so that the national actors can really, and it's hard to say this without sounding condescending, but so that those on the national level can learn how to do it properly, because there really is a need for that. But I think we can take examples from other places. The only other point I wanted to raise, the question of funds and which countries are really supporting Bangladesh, and does that go into the judicial system? Yes, it does. Whether it goes directly into the tribunal or not, we haven't been able to identify. But if you look, the House Subcommittee on Foreign Relations or Appropriations recently issued a statement effectively condemning the trials and really making the point that it does and it should have an impact. But the situation with Bangladesh is not just the trials. I mean, there are a whole host of issues to look at, regrettably. I mean, the whole human rights situation, the ready-made garment industry. So there are various different things that are being looked at in terms of whether we should continue to support. There was an FBI program to train members of the Rapid Action Battalion. That was, of course, suspended when Human Rights Watch issued their report saying that this group is responsible for a number of extrajudicial killings. So there is attention. There's just not enough attention to it.
And to Maitali's point, and the question about when do you pull out and then risk that the process gets worse than it is versus when do you continue to engage and potentially legitimize it, that's obviously a really difficult dilemma that any international entity has when they're working in a problematic system. And I think it's different for NGOs versus governments. So ICTJ has very high standards in terms of what due process and having their name associated with something. They are the experts on transitional justice. And I think at a certain point, it made sense that they had to say simply, we have to walk away from this. We cannot, it's not, there's not an openness or a willingness to hear our advice or to implement our advice, and so we walk away. I think it's very different when you're talking about a bilateral governmental relationship where Ambassador Rapp was just in Bangladesh, right? It's obviously a very problematic process, and yet he hasn't given up efforts to try and get some reform and some mitigation of some of the worst aspects of that process. And so that bilateral relationship isn't going anywhere, and it's a very complex one, and the funding question touches on it directly. There are multiple competing equities in that bilateral relationship, and there's very few countries that we completely cut off relations with, sort of Cuba, North Korea, right? I mean, we're not there yet with respect to Bangladesh, and so
getting there.
Maybe. But the point is that bilateral relationship can still be effective potentially if you can find the right interlocutors. One of the things my office helped with was getting a documentation center some funding so that there could be an independent monitor, not necessarily evaluating the process, but at least providing a sort of blog that talked about the ongoing proceedings, so you can get access to judgments linking to decisions that are made public. And none of that would have existed, unless you had the ability to enable this private entity to go forward. And so that blog is available. It's on the East-West Center out in Hawaii if anyone's interested. But they've long done sort of justice-related initiatives in Asia, and this is one more of theirs. And I think it's a very useful service. It's difficult because there have been lots of times because of these quote-unquote cartels, these strikes and other disruptions in the society that they literally have not been able to go to the courtroom. But at the moment they've had access. Now, unfortunately, that effort has run out of money, and so they're not able to do the monitoring anymore. And so there's a movement afoot to try and get them refunded so that there's some kind of eyes and ears on the process in getting that information out. But it's obviously a very complex problem when you're dealing with a bilateral relationship like that.
What about this report?
Oh, yeah.
That's right, expectations.
You.
Thank you. I have a comprehensive list. But not that.
The idea is to take this up during the UN General Assembly next month to ensure that the international community now starts to take this seriously. The difficulty is, of course, competing interests. I mean, we're competing with Syria, Iraq, Ukraine, any number of problems. But the idea is to provide a sensible set of recommendations that actually has some possibility of being implemented. But it is obviously very difficult. But it is primarily aimed at the United Nations.
And there was a question also about other forms of, other levers potentially to be invoked here with respect to due process. And an important one is the Human Rights Committee, which is a UN kind of experts body that's charged with enforcing the ICCPR. And Article 14 of the ICCPR, plus some additional articles of that multilateral treaty, of which Bangladesh is a party, sets forth, clear rights against self-incrimination, rights to appeal, rights that are in jeopardy with these processes and have been breached with these processes. And so I don't know when Bangladesh comes up before the committee, but reports like this one and other so-called shadow reports where the government will put forward its report that tends to be rather rosy on how well they're adhering to the treaty and their treaty obligations, and then non-governmental organizations will put forward these sort of shadow reports to educate the experts on that body as to what's sort of really going on. And so there will be a tough dialogue, in diplomatic Geneva terms, tough, that will happen where Bangladesh will have to defend its system. And so there's some places where at least they can't just operate in a vacuum, that they're part of an international community that has certain expectations and that will ideally raise some of the pressure and try and get some reforms moving.
And in the words of the foreign minister, actually the former foreign minister, when she was asked by, I think it was Congressman Steve Chabot, about the application of international standards, she said, we are establishing a new international standard in Bangladesh.
Okay, thank you, Beth. Thank you, Toby.